Pacific Legal Foundation is announcing today that we have just filed an appeal with the California Supreme Court in the California high-speed rail bonds case. The state is seeking judicial approval, or validation in the technical term, for $8.6 billion in bonds for the high-speed rail project so that it will be allowed to sell the bonds without any further legal opposition or complications. Pacific Legal Foundation is challenging these bonds in court because the bullet train project is not complying with basic legal requirements for openness and accountability to the courts, the taxpayers, and the public interest. This litigation is not about opposing the high-speed rail project. It is about demanding that the high-speed rail project be conducted with accountability, transparency, and consistency with legal and constitutional mandates. That's not happening now, so the bullet train bonds should not be allowed to go forward. The state Supreme Court takes only a very few of the cases that are appealed to it, but this should be one of those few. I believe this case, the bullet train bonds case, has state Supreme Court written all over it. This case raises historic questions about whether public works projects in California must be operated in a way that is answerable to the public and compliant with the law. And the size of the project is monumental. The bullet train is the largest public works project in the state's history. With stakes this high, the final ruling on the legal issues should come from the state's highest court. The bonds must not be approved at this point because the state has made no effort in court to answer those questions and demonstrate that today's project is what voters approved 6 years ago. In asking the Supreme Court to take this case, we argue that a bullet train bait and switch must not be allowed because it isn't just unfair to taxpayers, it is flat out unconstitutional. So we are asking the California Supreme Court to hear this case, the case of the bullet train bonds, in order to uphold the integrity of the law, ensure the credibility of the high-speed rail project, and protect the rights of the taxpayers of the state.
And as Harold pointed out, what the voters were told back in 2008 was an abject lie. They said a third of the money would come from the private sector, a third of the money would come from the feds. Well, we know that there's no private money out there that's going to invest in this boondoggle. And Kevin McCarthy, the new leader of Congress, of the House of Representatives, has made it clear they're not going to get a penny from the feds. So where's all this money going to come from? It's going to come from California taxpayers, and yet the taxpayers were told in 2008 that this would not be a taxpayer-subsidized project. That was an abject lie. If we lose this case, this will be a warning to every voter out there about every successive bond measure going forward, and that is, no matter what the ballot pamphlet says or what our state politicians say about where the money's going to go, there's absolutely no guarantee. So every bond measure presented to statewide voters going forward, the voters better realize are nothing but a blank check, because you will never know exactly what you're getting, because what we're getting with this is not what we were told with Proposition 1A. Thank you.
We're here today to talk about the issues at hand, and it is our hope, it is our prayer that the California State Supreme Court will take on this case. Some have questioned how a church would get involved in a case like this. As you look at what's going on in the state, the citizens of this state are taxpayers, those that voted for Proposition 1A. There were certain promises that were made to these individuals. And these same individuals, at this point in time, we know that they have questions about this rail project and how it's moving forward. And those questions are not being answered. And what we're seeing on the state level, what you're seeing on the state level, we're also seeing on the local level. Our church, our school, we're in the path of the rail alignment. We're just a few feet from the high-speed rail, and there are several impacts that we're seeing there at our church and at our school facility. We serve a lot of learning disabled students. We have a great ministry there within the church. And since 2008, since Proposition 1A was passed, we've had a lot of questions for the Rail Authority. We've went through the processes as we were supposed to. We submitted our letters, and yet we have also failed to see any true results. Our questions are not being answered. And with that being said, we feel it's important that our church organization and our school, that we move forward with litigation. And again, we are asking that the California Supreme Court take this case to help not only our school and not only our church, but also the citizens of the state of California. Thank you so much.